What's up, good people? What's up, good people? It's your boy, Dr. Leroy McKenzie Jr., the Impact Builder. Welcome to the brand new suite. Welcome to Think Different Greatness Thursday. I need your energy. I need you to give it to me. Y'all know what it is. Don't act like you don't know. I need you to give it to me. As James says, the Godfather says 3 times, I am greatness. I need you to I need you saying that to yourself. I am greatness. One more time. I am greatness. I want you to feel that energy all day today. I know it's raining outside, or it's off and on outside. That's why I'm inside today, because it's raining. So I had to do my walk inside today. So, but it's Greatness Thursday, and I want you to always remember you are greatness. I want that resonating with you all day today. You are greatness. Y'all know what we've been doing all this week, what we have been talking about. We've been talking about protect your brand, the legal side of branding, the legal side of branding, and you have to understand that there is a legal side to your brand, to your organization, and it's more than a logo. It's more than a saying. It's making sure that you, as a brand, are protected from all the way from your logo, all the way to and through your the partnership agreement that you might have, and we'll talk a little bit about that today. So understand that it is very important. This is probably one of the most important weeks, I believe, that I've done, because you don't want to put yourself or your brand in the position where you're vulnerable from a legal standpoint. And that's what this week has been all about. It's about protecting you and the different ways in which you need to protect yourself. We've talked about different ways. We've talked about copyrights. We've talked about trademarks. We've talked about just different ways of that you need to protect your brand, that you protect your identity, that you would protect your intellectual capital, all those things. So today is going to be no different, and we'll talk about today. We're going to talk about the contracts. We're going to talk about the agreements and the NDAs. And for those that may not be familiar, hopefully as an entrepreneur, you know what an NDA is. That's a non-disclosure agreement, and you have these in place to protect you, to protect those that you serve, to protect all entities that are involved and everything like that. Get it in writing. I need you to write that down. Get it in writing. Get it in writing. Because here's the thing: a handshake, a handshake sounds good, right? Hey, let's shake on it. Let's shake on it. That sounds good until problems show up. Yeah, it's all good until those problems show up. Then it's, well, you didn't say that, or I didn't say that. I'm not this, I'm not that, I'm not doing this, I'm not doing that. That's a handshake. Because here's what happens when you have the when you have the handshake, you know, it's your word against theirs. Oh, I forgot about this, or I'm not sure about that. And that's where professional brands come in, because a professional brand documents expectations. What are your expectations that you have in the agreement that you are talking about? Put it in writing. Many entrepreneurs, not saying many entrepreneurs, lose money, relationships, opportunities, because they failed to put the agreement in writing. And I in the brand you suite, we don't want you to be one of those brands. We don't want you to be one of those entrepreneurs. We don't want you to be one of those organizations. We want you to have the proper agreements, the proper paperwork, all of those things going into any situation. And I need you to have that mindset today. Protect your brand. Get it in writing. No matter, it's not personal. It is not personal. And if someone wants to take it personal, then you shouldn't be getting into an agreement with them anyway. They should want to have an agreement, because here's the thing, and why contracts matter, because it spells out those expectations that you have. It spells out the expectations that they have. It gives you an understanding of who has what responsibility, and the repercussions of not adhering to those expectations, or adhering to those expectations. What can happen, what will happen, if you either if you live up to those expectations, or if you don't live up to those expectations. That's why your contracts matter, and it gives you gives you the ability to be able to have something to be able to go off of and fall back to. There's no blurred lines. You're clear. Your contracts make it clear who does what everyone is responsible for. Your client agreements, you want to make sure that the client understands what they are responsible for. The client understands what you are responsible for. We talk about offer. Your offer is a contract. It's a contract, and it spells out for you what you're going to produce and what you're going to deliver. It gives those expectations. Here's the expectation that you should have for what we're going to deliver. Here's the expectation, or what what we're telling you we are going to produce. That's what your offer, your contract is. It's a contract. A contract is an agreement between two or more parties, and you're agreeing what you're going to produce, what you're going to deliver, and what happens if you don't produce, if you don't deliver. And so you want to make sure that it's all covered. Same thing with your partnership agreement. The partnership agreement is two either entities or organizations, two brands coming together saying, hey, we agree to come together to do XYZ. Partner A is going to do ABC. Partner B is going to do DEF. Everybody has a clear understanding of what their responsibilities are. Everyone has a clear understanding of what they are to expect. Everyone, there's a clear understanding of what your responsibilities are. You have the clear understanding of what my responsibilities are. It's all spelled out for you. And partnership agreements, there should be no stone unturned. You should know exactly, coming away from, before you sign on that dotted line, you must know what your expectations are. Before they sign on the dotted line, they should know what their expectations are. That way there's no blurred lines. There's no confusion. Somebody can't come back and say, well, that's not what we say. Well, let's see, what does the contract say? What does the agreement say? And when you have independent contract agreements, you want to make sure that, hey, there's the stipulation. This is an independent contractor. We are an independent contractor. We operate at this capacity. You operate at this capacity. That way it's clear. There's no misunderstanding, and the responsibility that comes with being an independent contractor. Your NDA'S, your non-disclosure agreements. Those non-disclosure agreements mean you can't talk about it, I can't talk about it, and everything about what we can and can't talk about is in that non-disclosure agreement. That means we have to keep it between us and no one else, other than the attorneys and those that are in the immediate have to do with the agreement, are the only ones that can have a discussion on it. And then protecting your confidential information, making sure, that's why you do these agreements, your non-disclosure and all of that, because you want to make sure that your intellectual property, that anything that you have that is of significance, you cannot talk about. And that's just like, I'm sure, KFC with those 11 herbs and spices, they have a, not because that those 11 herbs and spices are moved away where only a certain number of people know about it, know what that ingredients is. If you're getting into a contract with someone that requires that, let's say you're going to be you're going to be patenting something. You have a patent, and you have to have that patent um, has to be created. You have to have a proof that you create. And so the company that is going to manufacture that proof for you has to have, you want to cover yourself and make sure that you cover everything that needs to be covered for you. So you make sure that if it requires you to have them sign an NDA, they sign an NDA. And you always want to think about the protection first before anything else. You want to make sure that you talk about the protection, because professional brands document what amateur brands do not assume anything. You want to make sure that it is clear and it is in writing. I can't stress this enough about these contracts. There's so many entrepreneurs, there's so many organizations, so many brands that have gotten themselves into legal trouble, or they've lost legal battles because they did not put it in writing. Get it in writing. I'd rather you have it in writing and not need it than to not have it in writing and you have to need it. Like I said, it's not enough. It's nothing personal. This is business, and you're in the business of protecting yourself. You're in the business of protecting your brand. Protect your brand at all costs. That means from the smallest I to the biggest T. You want to make sure that you've made sure that everything that you need to be covered in writing is in writing. So here's the homework I need you to do. Where are you operating? I need you to think about this today. This is Think Different Thursday. We don't think, as entrepreneurs, you don't think like everybody else. So you have to think about this. Where are you operating on trust alone? Is there any aspect of what you're doing in your business that you're operating on trust alone? You might be friends, you might have a close relationship with them, but the fastest way to ruin a relationship is to not have it in writing. So where are you operating on trust alone? And when should you be operating with documentation? You have to understand which is which. Want to do The majority of the time you want to operate in with documentation and not just trust. Yeah, trust and documentation go together. I trust you, but I'm going to trust you enough to put it in writing, and you should not have a issue or problem with someone wanting to do the same thing with you. I know I don't. Let's put it in writing. That way, we're both protected. Protect your brand. Get it in writing. If this is something that you need to go into greater detail with, please connect with me, connect with us, so that we can have that strategy session. Schedule your strategy session. We can talk about how to go about protecting your brand in a deeper way, and having you connected to an attorney that can stipulate all of these things. We can have the initial discussion. Then those things that you need to protect you from a legal perspective, we will have an attorney that will be able to know the process and know those things that you need to be able to have protected, and to do, they can put it in writing for you, making sure that you are covered. Big businesses make sure that they are covered. So I want to make sure you, as a business, are covered just like everyone else should be. So it's your boy, the Impact Builder. Don't forget, hop on over to the YouTube channel. There's digital content that's here just like this, that is for your best interest, to make sure that you are 1% better each and every single day. Because I want you to have a clear understanding. I want you to have clarity, and there will be no chaos. Because when you don't protect yourself, when you don't protect your brand, there's chaos. But we don't deal with chaos. We deal with clarity. Clarity is having your having the legal documents that you need in place. So we'll be right back here tomorrow. Don't forget, masterclass tomorrow afternoon at 2 o'clock. LinkedIn, we will be there. The masterclass for protect your brand, where we'll go into greater detail about some of these contracts and agreements that we've been mentioning this week. So we'll talk to you soon. It's the Impact Builder. We out.